Okay, everyone. Thank you all for attending today. My name is Bibas Vaze. I'm a lawyer in Vancouver, and I'll be moderating today's panel, which is called Litigating Solitary Confinement. And we have four great speakers with us today. They will appear in the following order. John Conroy, QC, Hana Garson, Kate Mitchell, and Fergus, known as Chip O'Connor. Again, thanks for being here today. We will have questions at the end of the session. If you see at the bottom of your screen, that is at least as far as the Zoom panel is concerned, there's a Q&A section. I would ask anybody who has any questions to please type their questions into the Q&A section. And at the end of the panel, we'll be able to field the questions to the different participants. Each panelist today is going to speak for approximately 10 minutes, so that should give us a good 15 or 20 minutes for questions at the end. Okay, so getting started, as I said, today's panel is called Litigating Solitary Confinement. And that, of course, brings to mind two major issues that come in prison law. Of course, the major issue that has been in the news and which we are all very much part of studying and trying to understand is that of solitary confinement itself. But the second question that arises in relation to that is, how do we go about litigating solitary confinement? What do we do in order to make sure that prisoners' rights are preserved within that context? How do we get access to justice within that context as well? Speaking first to solitary confinement, as many of us are aware, there have been many developments in the last 2 years in relation to the legality of solitary confinement in Canada. As, again, most people would be aware, there was the successful constitutional challenge to the administrative segregation laws at the federal level that was launched by John Howard Society and the BC Civil Liberties Association, which was successful at first instance and further successful at the BC Court of Appeal. One of the issues that came up in that, or I should go back one point. The question then comes, what is the federal government response going to be with respect to that successful litigation? That is, in this particular case, the Attorney General of Canada did not seek leave to appeal to the Supreme Court of Canada. So again, the question is, what do we get from the federal government in terms of a response to the striking down of these laws? And that's where the big question comes. So what we've seen so far, a major response has been this concept of the structured intervention unit. And there have been many questions raised, and the panelists will speak about it, about whether, in fact, the structured intervention units will do anything at all. One of the things that was referred to in the judgment at first instance in the solitary confinement case by Justice Leask was the whole concept of what they called properly resourced subpopulations. So if you could create situations within the prison where there were subpopulations, it would take away from the need of the prison authorities to have to put people in solitary confinement when they have various issues they're dealing with, or that at least they say they're dealing with, such as incompatibles, for example, things of that nature. The early commentary on structured intervention units has not been positive. It appears that while they are trying to put these things together, they're not actually doing anything at all to really change the regime of solitary confinement. So the panelists will speak about that in particular. I think Chip O'Connor has many words to say about that. So that's the first thing. How are we dealing with solitary confinement? So then the question is, how do we then litigate that? Now, traditionally, or I shouldn't say necessarily traditionally, but starting at least in the late 1970s, with a lot of the work that John Conroy and Chip as well had done, led to us having the ability to go to court and seek habeas corpus remedies with respect to those who are in solitary confinement. And there have been tremendous developments in habeas corpus over the years. Sometimes we've taken 2 steps forward only to take 3 steps back. But starting in the late 70s with Martineau and cases like that John Conroy had brought, Again, in the mid-'80s, Miller, which was one of Chip O'Connor's, through to Gamble, to the early '90s. There was a period where the use of habeas corpus went far down, and it had to be revived again in the 2000s with May in 2005, again with Kayla in 2014. And we've gotten to what some of us think of as a high water point now, with it going into the immigration context, and last year's case of China that followed other cases in Ontario, such as Scotland, as well as Chaudhry. So it appears we have this great expansion. But then on the other hand, the access, the ability to actually access habeas corpus continues to be a big problem. And I believe Hana Garson and Kate Mitchell will both speak about the challenges that we continue to face in actually getting access to courts with respect to litigating solitary confinement, which this panel is about. Okay, so we're going to start with John Conroy today. And the question I'm putting to John is that, John, you, along with others such as Chip, are largely responsible for giving us the means by which to litigate the issue of solitary confinement in the prisons, including by way of the expansion of the use of habeas corpus. Could you tell us where we were at on those issues when you started your career? And when you started your career in the Fraser Valley, where most of the Pacific region institutions are located, and what were some of the major developments along the way that allowed us to get access to the courts and litigate the issues? And what are the lessons for the current challenges to solitary confinement? John? You're on mute.
How's that?
That's good.
Okay. So those of you who may know me know that as a result of my experience with imprisonment and release issues over now, I guess it's over 45 years, my favorite expression is there is no one more furiously cynical than an idealist betrayed. And I particularly, having looked at the Solitary by Another Name document, shake my head at how things have resulted from all of the exercise of peaceful remedies. I say that because my initiation into all of this was the Steinhauser hostage-taking incident, where Andy Bruce, Dwight Lucas, Andy an Indigenous person, Dwight Lucas a Black person, and Claire Wilson a white person, took 15 people hostage at the BC Pen because they were about to be put back in the hole, the famous penthouse, which was the subject of the litigation in McCann versus the Queen in 1975, where Justice Field in federal court declared at that time that the conditions and circumstances at the BC Pen in solitary confinement were cruel and unusual punishment contrary to the then Canadian Bill of Rights, which was not a constitutionally entrenched document. In the case against Bruce, Lucas, and Wilson, they were charged with extortion and trying to get a plane ride to Cuba and to get everybody's release from solitary confinement. They were charged with, of course, kidnapping and extortion, and they raised the defense of necessity, that the evil that they committed was a lesser evil than the greater evil of being subjected to cruel and unusual treatment or punishment contrary to the Canadian Bill of Rights. And they were in the process of trying to exercise their peaceful remedies at the time through the McCann case, and they were being prohibited from going to attend the trial. So I mentioned that to illustrate that at that point in 75, we were really in the beginnings of litigation. And these sorts of riots and hostage takings and so on were a fairly common occurrence. And so our major focus was to try and provide peaceful remedies. Justice Toy, unfortunately, took away the Bill of Rights component of the defense of necessity in his charge to the jury. And the jury, while it took them 5 days to make a decision in a case where we admitted 99% of the facts, came back and convicted of the extortion, and the Crown jumped up and stayed the other charge before the jury could render a verdict. So we never got to find out what exactly was going on, but rumors were that the jury was quite concerned about all the evidence they'd heard about solitary confinement. If anybody wants a transcript of the trial, in preparing for this, I went digging through my archives and actually found that I still have a full transcript set of that case. Anyway, so from then on, my involvement was Martineau number 1, first of all, and then Martineau number 2, trying to establish peaceful remedies so that prisoners would have peaceful remedies instead of the riots and hostage takings that we had. And as most of you know, Martineau number 1 and number 2 were basically first testing Section 28 of the Federal Court Act that existed at that time. And so we went to the Supreme Court of Canada on that to be told no jurisdiction. And then we continued because we'd filed both in the Trial Division and the Court of Appeal under Section 18. And ultimately, the Supreme Court of Canada declared or accepted that we were able to use certiorari to quash decisions. I should say, when I was first asked to go and represent Mr. Martineau and I phoned up a Matsqui institution warden, the attitude at that time was, we don't allow lawyers in here. So this was at a time when there was a lot of resistance to lawyers being involved in any way, shape, or form in terms of the prison situation. The next event for me was Cardinal and Oswald. I was on my way to dinner. I got a call that some hostages had been taken by Cardinal and Oswald at the front gate of Matsqui Institution. They were dressed up as a man and woman because they'd been acting in a play and they'd tried to walk out with all the rest of the visitors from the play and were caught at the gate. So I attended, and fortunately we were able to resolve it quickly, but and with some conditions that, and they knew they were going to be transferred to Kent. The whole objective was to try and get them to Quebec, where they came from and wanted to be. So they were transferred to Kent, and after they were kept in the hole at Kent solely because of the incident. And so after after 3 months, the Seg Review Board was recommending that they be put in the population. The warden was ignoring that and not telling them about that or telling them why he wasn't accepting that. So after 5 months, we filed the habeas. And the whole point was to establish that we could use habeas corpus to spring somebody from the prison within the prison into the general population. Up to that point in time, it was thought that you could only use it to spring one completely from prison and to eliminate any type of detention. So, as you know, Cardinal and Oswald, Miller and Morin all got heard together in the Supreme Court of Canada, 1985, and that clearly established the remedy of habeas corpus, with or without certiorari in aid, bearing in mind the federal court jurisdiction. So the peaceful remedy in order to try and do something about solitary confinement or what's going on or affecting you in solitary confinement, while other civil remedies would exist that obviously take much longer to resolve issues, habeas corpus is the one that exists and is the one that can get you into court the quickest. And I should say that up to that point in time, these were all prior, the fact patterns, even though Cardinal and Oswald in those cases weren't decided till 85 in the Supreme Court of Canada, the fact patterns were before 82, so they were pre-charter cases. And so in 1982, the right to habeas corpus to determine the validity of one's detention became a constitutional remedy under Section 10. And I say that's very important, especially if there's any further efforts, and I don't see any options for them to try and limit its use in terms of solitary confinement, but certainly they are attempting to limit it in other areas. And I would remind everybody that Section 1 of the Charter says that all of the rights and freedoms in it are only subject to reasonable limits under Section 1. And I don't think Section 1 has ever been argued as yet in any of the cases where efforts have been made by the government to limit habeas corpus. So to come back to where I was in terms of my cynicism and my despair at the situation that, I think it's great that we've managed to develop a prison law bar and to keep the correctional people on their toes all these years, and the work that you guys have done recently to keep after them. But I shake my head when I see what they are doing to basically not comply with the court order and to circumvent the decisions. And so that is what makes me continue to be cynical about the situation. I recently have read a book by Neil MacLean, who was a guard at Kent, who, I don't know if it's called Serving Life 25, One Guard Story. And so it occurred to me, given the amount of that we hear from time to time about the damage suffered by the staff and the guards, that maybe we should introduce in the next go around a huge part of the evidence showing how they are, what damage they're doing to themselves as well when they do these things to prisoners. I guess I'm grasping to try and find something that will get the government to really truly pay attention. My thoughts now, while I was happy that they didn't file an appeal to the Supreme Court of Canada, I now sort of wonder if it wouldn't have been better to get there and finally get a decision from that court that maybe they'd pay more attention to. So I come from a perspective after more than 45 years of dealing with these situations where it's clear to me that imprisonment dehumanizes everybody who's involved in it, staff and prisoners, and solitary confinement is the epitome of that dehumanization. And you can take, as Inger Hansen testified back in Steinhauser, you can take your most humane guard and make them work a solitary confinement unit, and within a few days, they will no longer be your most humane guard. Thank you.
Yes, thank you, John. And I neglected to introduce John's mini bio before he spoke, but John has practiced in Abbotsford, British Columbia for 45 years and was involved with prisoners' legal services and setting it up back in the 1970s when it came. So John was there at the beginning and he's here at the end, but this is far from the end, of course. So thank you, John. Our next speaker is Hana Garcin, who is a sole practitioner in Halifax, Nova Scotia. And let me just put a question to her. So Hana, you're the only person on the panel here today who is not from British Columbia or Ontario, where either fortunately or unfortunately, much of the jurisprudence surrounding both habeas corpus and solitary confinement has emerged. I also understand there are numerous challenges in the Atlantic region in getting prisoner issues before the courts, and that funding is a problem. Can you describe the situation on the ground with having prisoners get before the courts and some of the challenges you face both in litigating generally, as well as in getting the courts to be receptive to the issues?
Thanks, Vivas. Yes, absolutely. So I will talk about both habeas corpus and judicial review in terms of bringing prison issues before, or attempting to bring prison issues before the courts in primarily Nova Scotia, which is where my experience of these issues would stem from. So unlike Ontario and British Columbia, there is, I would say, next to no public funding for prison issues. So for example, the legal aid Nova Scotia does not, as a policy, does not cover prison related issues other than the determination of conviction and sentencing. And once that happens, it's more or less, if you have the capacity, do it yourself or find a way to pay privately. And as I'm sure probably all of the listeners know, that's very difficult for a largely impecunious and population with limited access to education, especially if the individual trying to self-represent is trying to do so from a segregation cell. So this creates a twofold challenge. One is, in the meantime, what to do to try to provide some kind of systematic advice to those who are self-representing. And second of all, well, how do we try to find some kind of funding? There is, I would say, the minimal representation that occurs now would be from Elizabeth Fry Society, so exclusively for women, and only occasionally, because Elizabeth Fry Society has managed to get some funding for a part-time lawyer. Or alternatively, I would say once in a blue moon, legal aid, very generous managers at legal aid breach their own policy to give a certificate or two for lawyers to do habeas corpus applications. However, I would also say that unsurprisingly, as there is literally no financial payment available for a profession in prison law, not many people decide to train themselves in prison law because it will lead to a life of very challenging pro bono representations. Therefore, most of the time, in fact, people don't even want to take the limited certificates. Surprisingly, they don't want to volunteer for 100 hours of prison law. So the question becomes, how do we train idealistic students to decide to want to voluntarily do prison law in the meantime? So Elizabeth Fry and East Coast Prison Justice Society has tried to train people to do habeas corpus. It wasn't particularly successful, as it didn't seem to motivate people to want to give away many hours of their time for free to do a different, new and challenging kind of law where the chances of being successful are almost none. Occasionally, there are clients who can pay privately for a habeas corpus. So most advice is summary advice, and almost all habeas corpuses are self-represented. And this is very problematic. It creates awful precedent because the self-represented individuals do not know how to properly advocate for themselves. And then the institution, who's often represented by more than one attorney general lawyer, gets a very good decision for them. And it's been warping the precedent in Nova Scotia in ways that are kind of unexpected. So for a while, there was a standing case in Nova Scotia against a self-rep saying, creating a new step that the self-represented individual had to do to surpass a certain threshold to enable a habeas corpus to even be considered on the front end. This was a case called Pratt versus the Attorney General, and it was appealed successfully, and it was found that the judge had actually communicated in secret with the Attorney General without providing the information to the self-represented individual, and even getting information after the fact to include in his decision. So it's good that that decision was appealed, but there are other decisions that stand that are not appealed, because appeals also take a lot of time and resources that we don't really have. So another issue with self-reps is they're subject to more, I guess, trickery or attorney general trickery than a lawyer may be. For example, quickly cases becoming mooted because individuals being let out of segregation, and then the individuals instantly resegregated. And this may, diminish the persistence of the self-represented applicant, not knowing the law of how to deal with the issue of mootness. So we've tried a variety of strategies to try to help the self-reps. For example, accessible guidebooks for habeas corpus, or as I said, providing summary advice. Although the fear is, and it's kind of manifest, this actually has increased the number of applications of habeas corpus without increasing the number of successful habeas corpus applications. And then the fear becomes, well, are costs going to start getting slapped on these self-represented applicants, which would have a chilling effect. One of the other issues is habeas corpus, though fairly inaccessible to self-reps, is far more accessible than a judicial review. So many of the issues that intuitively may be covered by a habeas corpus application, for example, a lockdown range, it seems fairly similar to segregation, except it's with a whole bunch of inmates, has not been determined to be available to be challenged through habeas corpus, and then it would be challenged through a judicial review. However, judicial review is just largely outside of the knowledge base of self-represented inmates, and delineating which issues should be litigated through judicial review and which issues should be litigated through habeas corpus is not really an assessment that can be made strategically by inmates, who all tend to choose habeas corpus, although get shut down at the front end with with the words basically that it's not an issue properly addressed by habeas corpus, and no real option of trying to figure out or educate about judicial review. There's kind of a thought that perhaps judicial review self-rep guidebooks should be distributed amongst inmates, although that seems like it may not be particularly successful. It may have an equal chance of success as opening up the definition of habeas corpus before the Nova Scotia Supreme Court. Another thought for a while in Nova Scotia was to try to push through litigation, because seemingly kind of lowercase p political strategy and trying to get more funding for prison issues hasn't really been very successful. There was a consideration of trying to do a challenge like that of Winters or JG, trying to establish, or the New Brunswick versus JG Supreme Court of Canada case, trying to establish that because there are such high stakes Section 7 liberty stakes, that the government should have to fund these sort of issues. Although research has been done in the background trying to figure out if this is a case that should be brought, when should it be brought. The problem is, again, this building a case properly for that takes a lot of time and effort, and is again a pro bono undertaking. So basically the result is that both provincial and federal prisons, I would say largely in the Atlantic region, although my experience again is more in Nova Scotia, are able to act with impunity. So in Nova Scotia, there's one particular provincial prison that's essentially been on lockdown for about a year. And no habeas corpus has been successful at challenging it. In fact, each Supreme Court decision from Nova Scotia more or less just defers to the decision of the correctional administrator in locking down, about half the population of their prison with no procedural guarantees, because any of the procedural guarantees that are given to an individual on segregation disappears when you're segregating a full range or unit. So I would say, I would like to say something hopeful about the potential to change the economic structure of prison law. I don't particularly think at this time that, because of the pandemic and the economy, that it's more hopeful now than it was a short time ago that Nova Scotia will be able to find some kind of economic structure to support prison law. For a while, ongoing, there was thought, we created this project to get data from provincial prisons based on what the need was, what are the level of rights breaches going on, based on phone calls and visits from to the institution and phone calls from the institution, to get some kind of aggregate data, to provide the data to some sort of funder or perhaps the government, to say, look, this is a statistic. Statistics tend to persuade people far more than anecdote. Look at what a terrible number this is. Perhaps it would be persuasive to provide more funding. Although, as I said, I'm not so sure that that will be an effective strategy based on the current economy. The Premier of Nova Scotia recently made a very heartfelt apology for the discrimination in the criminal justice system. And if the apology is truly as heartfelt as I'm sure it is, perhaps that will lead to increased funding for prison law, which is a tool to try to protect against more systemic racism in the criminal justice system. But as John said, I'm not so sure, based on my own skeptical views, that I think the promise will lead to that. That being said, at this point, the only consistent funding for prison law in Nova Scotia is through the Elizabeth Fry Society, and then the very occasional charitable gift of a 5-hour certificate occasionally for a habeas corpus out of a legal aid office. Or we can hope that more wealthy criminals are imprisoned. Perhaps that will lead to more funded prison law. Aside from that, just kind of more strategizing between some organizations here, East Coast Prison Justice Society and Elizabeth Fry, in thinking of perhaps a litigation to get, or to hope that the court would order that it's a right to have government funded prison law, or that we'll get some data that may be effective in lobbying, or not lobbying, but in persuading government based on this data that it should perhaps fund, perhaps through legal aid or perhaps to a nonprofit, prison law more systematically in Nova Scotia. Those are my comments for now.
Thank you, Hannah. I must say, having worked with both you and John, I didn't know that collectively you had such little hope. I don't know if hope is the right word to use at this point, but I guess we start at one point and we get to another point, and let's see where we get. Well, I think your comments will probably segue nicely and go very well with the comments of Kate Mitchell, who is coming next. And Kate practices at Boris Law in Kingston. And of course, being in Kingston, there's a lot of prison law going on there, although I understand that there's a lot of work that Kate's office is doing outside of Kingston as well, including in Toronto. Previously, I had emailed Kate a very specific question just about access to justice and things of that nature within the context of habeas corpus. I think I'll just set that up a different way just now, just to provide one piece of background, and you hear this both from John and from Hannah, is one of the things that we were stuck with is that by the time I think the law had gotten to the early 1990s, there had been a lot of progress as far as habeas corpus was concerned. I mean, there were a lot of innovative cases with habeas corpus as well by the early 1990s. During the 1990s, there was a period where there was a huge rollback, primarily in relation to things such as jurisdiction and things of that nature. And then thankfully, we had the case of May in 2005. But I was in the position, unfortunately, in British Columbia, as then being one of the younger lawyers, who was being encouraged to make sure that this great writ that had been expanded in May continued to have expansion. And of course, what I found, and that's what ultimately led to Kayla later on, was that DOJ was continuing to do everything they could to limit the use of the writ and therefore limit access to justice for prisoners. And they would primarily do it by way of jurisdiction. They would even do it by way of how do you get into the registry, things of that nature. And with habeas corpus having opened up so much now in those last 2 years, particularly in the immigration context, what I'm hearing, and this is what I hope Kate can help us out with a little bit, is that those same tactics are starting to come into play. And so my question for you, Kate, is what do you find are now the tactics, you being in a position where I think your office and you in particular are one of the people we're going to hope for in terms of making sure that we keep the writ of habeas corpus honest and that there aren't all these efforts made to continue to roll back what we've gotten. What do you see as the methods and attempts by government lawyers to try and limit ultimately habeas corpus, whether it be by jurisdiction, whether it be by access, things of that nature? And what are the methods that you are using and the methods that you would recommend to roll back, or I should say push back against those constant efforts by the federal government to limit what should be an open writ?
Yes, thank you. So there are many different challenges, practical and legal. Just quickly by way of background. So habeas corpus, just to clarify, it's an application brought in Superior Court to challenge unlawful deprivation of liberty. Correctional decisions, they can also be challenged in a judicial review application in the federal court. But of course, those take considerably longer to have heard. So habeas corpus is certainly our preferred means of trying to very expeditiously challenge the deprivation of liberty. And the procedures, they change a bit province to province, but in general, there's a two-step framework. First, the applicant, the prisoner, needs to establish that there's been a deprivation of liberty. And then the onus shifts in step 2 to the respondent, the Attorney General of Canada, to show that that deprivation was reasonable. So in terms of the challenges, I think the first one I just have to address is probably the most practical, which is just getting access to prisoners and their documents. The unavailability of legal aid, as Hannah discussed, is a real problem in other jurisdictions, and I'm quite lucky, I suppose, in Ontario, we have any coverage of such matters, but we still have the delays that come along with getting legal aid, and then getting in to see prisoners and get their documents, very challenging. And especially for people in solitary confinement, it is extraordinarily difficult to get in. And parole officers may or may not be helpful getting us correctional documents. And until we can get those documents, it makes it hard to do anything to get into court. And if we can't bring an application within about the 30-day time frame, sometimes the Attorney General will kind of resist our ability to even pursue the matter. So those are some very serious practical concerns. And then I think the second set of challenges I would address is just getting a date set in court. It can take an extraordinarily long time to schedule these matters, at least in Ontario. I understand different provinces, habeas corpus applications get prioritized and you can get access to court space a lot sooner. But my personal experience has been one of great delay trying to get these matters scheduled. We might be able to turn out an application very quickly, but then it gets put into an assignment court. And then you're looking at setting dates. And the Attorney General doesn't want to set dates because they don't have their materials prepared and they have no concept of how long that will take. So we come back month in and month out just to see where they're at with their materials, trying to set a date. And I understand there are certain time constraints and it does take time to prepare materials, but it is frustrating from the perspective of our clients that they're sitting there, and certainly inconvenient to prepare your materials on short notice, but it's also inconvenient to have a deprivation of your liberty. So we've been trying to negotiate our way as tactfully as we can with the AG, but certainly COVID has been a very significant problem as well. And we have had the Attorney General really resisting arguing any habeas corpus applications. We had one application filed back in May, and we're still fighting about whether or not we should even schedule a date for that right now, and whether or not that's an urgent matter. And it's frustrating from my perspective, because frankly, if a deprivation of liberty isn't urgent, it begs the question of really what is. And the time that we're spending arguing about whether this is urgent is time we could just be spending arguing the merits of the motion. So it's something that certainly eats up a lot of our time, and particularly in the Toronto court system, it is a confusing system. You will leave messages and send emails to people who never get back to you, and people end up waiting many months to just get dates set. And then they end up going moot. And that's incredibly frustrating because some clients want to still pursue matters, and the courts, given COVID, don't really have the capacity to be hearing a lot of moot matters. So we're kind of stuck in that bind. But the Attorney General will, graciously agree to not seek costs if we pull the application. So suppose that's them throwing us a bone, but it is what it is. The third set of challenges I would address would be the rules. We at our firm have historically filed under the criminal law rules just because it keeps things a bit more streamlined in our opinion, and it hasn't really been an issue up until very recently. And very recently in a couple of our applications, the Attorney General has really dug in their heels over this issue and insisted that we file under the civil registry. In certain cases, we've just agreed to this because We want to get to the heart of the matter. We don't want to spend time arguing motions just to get to the habeas corpus application. But it is becoming a bit more of an issue for us because even recently, the Toronto court is insisting that we pay the filing fees in the civil registry. And that's not an insignificant cost for prisoners who maybe are making several dollars a day, $229 just to initiate a habeas corpus application. That's a very significant deterrent to somebody. And I think it's frankly a bit distasteful that anybody should be paying to challenge a deprivation of their liberty. But by characterizing it as civil, that's a problem we're encountering now, and one that I think we're going to have to start resisting, especially because when we're under the civil rules, the Attorney General also wants to start bringing motions now to strike our applications for being frivolous, vexatious, and abuses of process. So again, before we can even get to the substantive hearing, we're spending days, weeks, maybe even months arguing preliminary issues before we can even just set the hearing date. It's not the most efficient use of time, and it means many of our clients are sitting in custody being deprived of the state of liberty for months longer than really they properly need to be. So that is another frustrating one. I think the fourth challenge I would just highlight would be cost awards as well. If you bring a habeas corpus application and lose, there's the risk of having to pay costs to the Attorney General. Usually it's only a few hundred to maybe a couple of $1,000s, but again, that is a tremendous amount of money to someone incarcerated who makes only a few dollars a day. Sometimes the Attorney General is willing to not seek costs, but we've been seeing more and more when the applications proceed to a hearing, the Attorney General insisting upon those. And it's one of those issues, again, I think is worth pushing back against, but it's one that is mixed. Some judges will recognize that this isn't an appropriate case for costs, but others, they will. And it's something that I personally don't like to see. I don't want to see any of our clients strapped with a cost award. And it's a real deterrent for people pursuing any habeas corpus application. And then the fifth and final challenge I'll just address is with the structure of the habeas corpus framework. As I mentioned, there are two stages to the habeas corpus framework. The first one is establishing that there has been a deprivation of liberty. And we spend a lot of our time arguing about whether there is a deprivation of liberty. It's one of those terms that is very ill-defined, and in the correctional context, I would say has been very narrowly defined. In certain cases, it's just widely accepted that it is a deprivation, an involuntary transfer, a segregation placement. The Attorney General might just accept those, they normally will. And then we just talk about stage two, the reasonableness. But in other cases, we see the Attorney General really digging in and insisting that it's not a deprivation of liberty, that habeas corpus isn't the framework for this. It should be pursued through a judicial review. So things like out-of-province transfers, healthcare decisions, issues with visiting, lockdown conditions. And the Attorney General wants to keep this category narrow because then they don't need to justify the reasonableness of the deprivation. But I really take issue with this because the case law seems to really, especially lately, be emphasizing that habeas corpus is meant to be a very broad remedy to address all types of deprivations of liberty. And we see this in cases like R.V. Wang from the Ontario Court of Appeal, the Torre case, I believe that's also Court of Appeal, the China decision that was mentioned, Supreme Court. So it's something that we're actively resisting, but it seems that the judges seem to also want to take a more narrow approach to what is a deprivation of liberty. And we have some ongoing cases right now trying to really push the limits of that in light of this more recent case law. Because really, when you limit what is a deprivation of liberty, it prevents people from being able to expeditiously challenge decisions that affect their liberty, no matter how arbitrary or unlawful those decisions are. And that's really contrary to the purpose of the remedy. And then stage two, of course, is also a concern, because when we're assessing the reasonableness of the decision, it's a standard of deference. And there is really this strong history of taking a hands-off approach in the correctional space and showing high deference to decisions of correctional decision makers. And the AG really continues to push for this and showing deference. And even in the solitary context, there is still that understanding that correctional officials, they can be trusted to do what's right for safety and security. And I don't think that's necessarily true. And even the Canadian Civil Liberties Association in Canada, the Ontario case, seem to acknowledge that just because correctional authorities rely on the appropriate statutory criteria, it doesn't avoid the risk of grossly disproportionate harm. So I think it's really important to be pushing back against the deference that we're showing. And also, I would just note to be demanding better decisions of correctional authorities who want to deprive liberty. And the 2019 Supreme Court case of Vavalov, I think, is important in the correctional context, emphasizing that decisions need to be sufficient. They need to be properly justified. We can't even begin to assess the reasonableness of certain decisions we've received because it's unclear as to how they even reached that decision. So again, I think that I try to remain hopeful, and I think the case law has been pushing the pendulum to making habeas a more robust and coherent framework. But really, the AG has been working very hard to push the pendulum back the other way. And we're working on a lot of cases to try and resist that, but we'll have to see. And I would just encourage all other lawyers to be aware of these challenges and do what they can to resist the AG trying to limit the scope of habeas. Thank you.
Thank you, Kate. Kate, I actually just have a quick question to start. When you talk about the DOJ effectively pushing back against on the basis of urgency, are you finding it the same in situations where people are in a position of solitary confinement versus somebody who's been subject to a transfer?
It just seems to be more or less across the board that we're getting resistance. And I'm not sure if those are just effectively the marching orders for the Attorney General or not, but every time we've tried to pursue a matter, and solitary hasn't come up all that often, but the general theme is they want to resist pursuing anything. Nothing is urgent in the habeas corpus context, apparently, at the moment.
Thank you. Thank you very much, Kate. And I think that leads to some questions that we're going to have to get at as well with jurisdiction in the federal court and all, but I'm sure people will have those come up. So thank you once again, Kate. Okay, finally, we have Fergus J. Chip O'Connor. I've never talked to Chip about how Chip came from Fergus, but I hope I can find that out someday. I don't know where to begin in describing Chip's career. He was there at the beginning and going to the Supreme Court of Canada and Miller, which, as we've just been talking about, there's this whole section, I think it's at the final paragraph of Miller, where they talk about expanding and conditions of confinement and how habeas corpus should be applicable possibly to conditions of confinement. Perhaps Chip can talk a little bit about that. But so Chip was there right at the beginning with Miller, and he's been there more recently with cases such as Ipali and others. So he has done much to advance the cause of rights of both people before the criminal courts as well as for prisoners for, I think, also about 40 years in Canada. So Chip, what I would put to you is that now we've gotten to this late stage of this concept of the structured intervention unit. That's what is coming up. And I know you've taken some interest in that. Based on your experience, how would you suggest litigating with respect to the problems that are associated with those structured intervention units?
First, I wish to apologize. I don't have a camera on my computer, so you won't be able to see me smile when I tell you that the name Chip I got the name Chip because my parents met through a computer dating service. And I'm smiling because you'll know I'm kidding.
Really?
I want to thank Murray and the John Howard Society for inviting me to participate. The Shakespearean analogy is apt. A rose by any other name would smell as sweet. Solitary confinement by any other name smells the same. In 1980, in Martineau number 2, argued by our esteemed fellow panelist John Conroy, Chief Justice Dixon of the Supreme Court of Canada said, quote, "The rule of law must run within penitentiary walls," end quote. This principle of law is the foundation of what we do as prison lawyers. I'm very happy to be on a panel with John, as well as Bibas, Hannah, and Kate, highly skilled lawyers dedicated to enforcing the rule of law within penitentiary walls in Canada from coast to coast. Almost 20 years after that principle was enunciated, following an inquiry into certain events at the now defunded Prison for Women, the Honorable Louise Arbour commented in 1996 on the Correctional Service of Canada as follows, quote, "The rule of law is absent, although rules are everywhere," end quote. Madam Justice Arbour added, quote, "The absence of the rule of law is most noticeable at the management level, both within the prison and at the regional and national levels. The rule of law has to be imported and integrated at those levels from the other partners in the criminal justice enterprise, as there is no evidence that it will emerge spontaneously." After yet another year's plus, this month, on November 15th, on the current subject, structured intervention units, Professors Anthony Dube and Jane Spratt reported, quote, "We could find no period when the SIUs were operating in a fashion contemplated by the law," end quote. They go on to say that to operate according to the law, quote, "would require hard work by the Correctional Service of Canada. We are disturbed by the fact that we see no evidence that this is happening," end quote. Does anyone see a pattern here? I do. What does this pattern observed over the past 40 years tell us as advocates? It tells me that all of us, particularly lawyers, must be alert and diligent in the process of educating jailers about their duties, urging jailers to abide by the law, and when necessary, taking jailers to court to enforce the law. I take this opportunity to say the requirement to provide 4 hours out of the cell is a huge and excellent provision. I give a shout out to those who argued the British Columbia Civil Liberties Association versus Canada and convinced Justice Leask to render that judgment. I particularly like paragraph 247. That decision has led to the end of administrative segregation. The 4 hours out of cell has resulted, and this is a very positive change. Nevertheless, make no mistake, solitary confinement continues. The SIUs are today's solitary confinement regimes. So to answer your question about remedies, habeas corpus versus federal court is a long-standing ongoing question. Kate has given some insight on that. In addition, there are some procedural and due process issues with the new regime, and I hope to be able to elaborate if time permits. But I would like to say at this point how I start approaching an issue, and that's what I refer to as grassroots advocacy. And to John and the others who express cynicism, I would say hope springs eternal, and folks will be folks. When I learn of a client's placement in solitary confinement in an SIU, I write to the warden immediately with specific requests, politely reminding the warden of the duties placed upon the CSC by statute, and I cite the statute. I have 4 goals in mind. My intent is A, to pay due respect to that official who has a very broad discretionary power. B, to educate that official, if necessary. And C, to urge compliance. And D, to create a paper trail to use in court if the rule of law is violated. As Kate has pointed out, litigation is time consuming. As Hannah has pointed out, there's funding, there's all sorts of issues. I start by hoping that we can achieve a result without litigation. Specifically, in the case of SIUs, I ask for the following. 1, a copy of the record made upon my client being placed in the SIU, including the details of, quote, the reasons for granting the authorization and any alternatives considered, end quote, which is required by CCRA section 34.2. 2, confirmation that oral notice that the authorization was granted and the reasons for it was given to my client within 1 day of his transfer, as well as a copy of the written notice with reasons which was required to be given to the inmate within 2 days, as required by CCRA section 34.3. 3, confirmation that the institutional head has reviewed or will review the said placement within 5 working days, and a copy of the documentation produced in relation to that determination, as required by CCRA section 29.012. And 4, I state that section 33 of the CCRA provides that confinement in the SIU is expected to be as brief as possible, and ask to be informed of what the expectation is in terms of my client's release from the SIU. So that's what I write to the warden, and that's how I advocate. I don't make any demands as to how the warden should exercise his power. My communication is calculated to educate and to monitor on the subjects of due process. I also send a copy to my client. Win or lose, it is essential to keep the client informed. The client needs to know that there's someone out there working on his or her behalf. Okay, I guess I got some time, do I?
Yes, you do. Please go ahead, Chip.
Okay, so as for the regime, the current regime, and I'm hoping John Connery will get a chance to comment, because John, you argued Oswald and Cardinal. In Oswald and Cardinal, if I'm not mistaken, you convinced the court that the warden has to interview the prisoners in segregation and consider what they have to say. Since June of 2019, under this new regime, there's no requirement that the warden meet with the prisoner. As well, the new regime does not call for a hearing. We used to have the Segregation Review Board hearing. It calls for a meeting at which the committee explained their proposed recommendation. Here is response. Then the warden considers the proposed recommendation and the inmate's response and makes a decision. So I ask myself, and maybe others will have some comment, does the new regime erode due process for those placed in solitary confinement? Secondly, the old Segregation Review Board was made up of staff at the institution. The new Structured Intervention Committee must be made of, quote, staff members who hold a position higher in rank than that of the institutional head, end quote. These officials are likely busy. The 5-day Seg Review Board review is gone. There's only a 30-day time limit now, subject to the as soon as practicable requirement. A meeting is mandatory, but will it be meaningful and will it be timely? Have we gained an element of external oversight at the cost of expeditious resolutions? And corollary to that is external oversight. Is this really external oversight? Because we're talking about officials within the CSC higher in rank than the institutional head. And as I've indicated earlier, what Justice Arbour found was that the absence of the rule of law is most noticeable at the management level. So one has to ask the question, are these higher officials going to respect the rule of law more than the old regime, the Seg Review Board? And then my third issue about the process, we've got this new external decision maker. And the external decision maker is given authority to, quote, determine if the inmate should remain in the unit, end quote, and in some cases, quote, direct the service to remove the inmate from the unit, end quote. My question is, does the CSC have a corresponding duty to do what the external decision maker determines or directs? If not, are the external decision makers just window dressing? Thank you.
Thank you, Chip. That's very illuminative. Actually, a couple of questions. So we do have some questions in the question and answer box, but I'd like to ask one thing, perhaps both of you, Chip, and maybe Kate, you can talk a little bit about this, about the jurisdictional question with federal court and habeas corpus, which we've sort of danced around a little bit over the course of talking today. Again, for the participants out there, one major reason why they would try and limit habeas corpus was because they would want to force people to go to federal court for judicial review of any decisions that were made. And of course, federal court is a very, very long process. This is talked about at length in most of the habeas corpus decisions, but particularly May as well as Kayla. So they wanted everybody to go into federal court because they knew it would take longer. And as Kate said in her presentation, that would effectively moot things out and then they don't have to worry about it. Of late, there has been some discussion about the idea that there is an expedited procedure in federal court. Can anybody comment on whether or not, well, again, first of all, going back to the ultimate issue of them trying to force us into federal court, but has there actually been any success? If indeed you've got to go to federal court to get there in a more expedited fashion?
I would say that the problem with the federal court is you're at their mercy in terms of scheduling. In habeas corpus, you file your you serve and file. In the federal court, you have to go to the court and then get them to, you know, more or less set a date. In habeas corpus, you call the trial coordinator and you ask for a date. And yes, there may be problems, as Kate has pointed out, with you know, assignment courts, but if you can get the trial coordinator to talk to a judge and explain the urgency, because not every habeas corpus is as urgent. There's degrees of urgency, but if it is indeed, in the case of segregation, the person's been just placed in, you know, you're talking about you know, substantive, procedural shortcomings, Section 7 arguments. Your client may have all sorts of problems from ADHD to FASD and all sorts of things. So if you can convince the trial coordinator to get a judge, so then you get the ear of a judge, not just a bureaucrat, and then you can get in there quickly. You know, whenever liberty is at stake, my policy is do everything I can to get habeas corpus pursued.
Thanks. And Kate, any success with federal court?
No, I mean, we haven't personally had any luck getting anything heard expeditiously in federal court, but I know that others have, and it can be done. It's just, it's a high bar to get things heard on an expedited basis. Certainly the federal court doesn't like to schedule things on such short notice and avoid the normal timeframes for serving different material and responding. And yeah, I would probably echo what Chip says. Certainly not all habeas corpus applications are as urgent as others. And sometimes the judge is helpful with at least nudging things along. But it is challenging in some cases, because so many cases, the attorney general, they'll just throw up their arms and say, well, we need time for our materials. And it can still be challenging to move things along. But it can be done in the federal court. I just haven't had any luck with it myself.
Okay, I have heard of some instances, I think in BC, where things did get expedited, but it was only once. And I can say that what you spoke to, Kate, about them trying to put us into the civil registry, we've always just walked, at least in BC, we've always walked things down to the criminal registry, just because they know what to do with these things. Mm-hmm. But I have started to hear more rumblings about trying to put us into civil registries, precisely for what you were talking about earlier. So. Thank you for that, Kate. Okay, I've got a few different questions here. Let's start with this. And one of the things I can say, we've been talking about the federal prisons mostly, but there are the provincial prisons that sometimes can be even more of a shall we say, zoo-like atmosphere than the federal ones. So the question we have with respect to that, it's for Hana. It says, question for Hana, in your view, are there more rights violations occurring in provincial prisons than federal prisons because they don't have the same procedural protections as the CCRA?
I would say it's different. The worst, I would say it's different. It's not necessarily just because of the CCRA, because many of the common law holdings in cases based on the CCRA are then could also be held to be applicable to provincial prison. But I would say that many of the individuals who I speak to in provincial prison have simply different concerns. The influx of new people all the time in and out of provincial prisons that are also remand centers causes all kinds of continual disturbance and fear, and a fear-based environment. There are broad lockdowns with little procedural, to no procedural rights in those circumstances. But then I would say the individuals who are in federal prison may have decades of lack of access to appropriate programming to enable them to get parole. And then they have full chapters of their life that have essentially been taken from them and destroyed. And that's kind of a different rights breach. And it's kind of hard to say. It's definitely not, I wouldn't say, well, what's going on in provincial prison isn't bad at all. It is terrible. But many of the issues I see with people in federal institutions are, full decades of people's lives being taken from them because of their inability to have a fair parole hearing for whatever reason. And I certainly wouldn't say that anything written in the CCRA has managed to protect them whatsoever. So I would find it difficult to make a clear statement saying that provincial prisons have worse rights breaches. I don't think that that's necessarily the case. And I don't necessarily think that I'm not so sure that the Office of the Correctional Investigator makes the actual living experience of individuals in federal custody far better than, or provide necessarily effective oversight at ensuring everyone's sentence is served in a fair manner. Even though there's no provincial, at least in Nova Scotia, I know it's differing from province to province, but even in Nova Scotia, there's no provincial parallel. Like our ombudsperson doesn't fill the OCI role.
Well, thank you for that. I think part of what the questioner was perhaps asking is, again, and I can say my experience in BC is that there's the BC Correction Act, doesn't have nearly as much as what's in the CCRA, and it bears out in terms of some of the cases that have come before it. I've heard in other provinces, it's even much, much worse. I don't know, John, you've done work with Surrey pretrial and the other institutions. I don't know if you can illuminate that question a little bit more.
No, my experience with provincial prisons was that the sentences were often so short that by the time you got into court, you weren't, it was moot. So I didn't have much success in terms of, I would say, getting into court quickly on provincial cases. I've had one, I think, recently, and I think it's because of COVID, because we're doing it from home. So I've had one federal court application that we were all surprised at the early date we got, but I think it was simply because of COVID and other cases falling apart. Our practice years ago was to file in the criminal registry. And then we realized that there were distinct civil and criminal habeas corpuses. And so we realized that most of what we were doing was probably civil because we weren't involved in any aspects of the criminal code, even though we said, look, this is criminal because it involves imprisonment. My memory is that at least in Vancouver, we used to file in the criminal registry only because they knew how it all worked, but it was considered to be a civil application. And there was a provision where we didn't have to pay the fees, or we could pay low fees if you were in forma pauperis. And there was also, I'm trying to remember, but there seemed to be a way anyway to, in terms of habeas corpus, through the procedure we had, that's how we could get costs against the government, as opposed to, of course, the risk being costs against your client. But as you know, Bibas, from that one non-solitary confinement case we filed to do with a person on an international transfer, where they were still in the US and we were trying to get the federal government to make a decision on the transfer. We filed in federal court, and the hearing date we finally got was, I think, about 6 months away. So we also filed a habeas thinking, well, we'll get in quicker. And interestingly enough, we did get in quicker, but not much quicker. I think it was maybe two weeks earlier or something. And but it was interesting. The judge granted us the habeas, but not any order to compel the decision. And so we rushed over to federal court for the date we had, and they wouldn't hear us because we'd already been at peace in Supreme Court. And ultimately, the Court of Appeals said the judge shouldn't have granted the habeas anyway because the prisoner was still in the US. But I've got one I'm talking to Bibas about, where the prisoner is now here on parole. So I think we'll try a habeas because we're arguing about the equivalency determination of his transfer offense. So we'll see.
We'll see indeed. Okay, we have a couple of other questions, and we have just a little bit more time. So another person has asked, question for everyone. Do you see Vavalov impacting reasonableness review in a significant way for habeas applications? Suppose Kate might be one person to speak to this. I know it has come up in a recent unsuccessful habeas corpus that I did, but anybody on the panel can comment, but please go ahead.
I would say that definitely, you know, this is a wrinkle in the law. It's a clarification of Dunsmuir, and you know, it gives a bit of a broader definition, or gives you a broader approach to reasonableness. So yes, it's a useful tool.
Anybody else?
Yeah, I would definitely echo that concern. And every correctional matter that we bring forward, more or less, we have to put Vavalov in there, because I think it does emphasize that where you do have more severe restrictions on liberty, or decisions that affect rights and interests more severely, you're entitled to better reasons, more justified decision. And so I think that it's important to bring up. I think the case is still fairly new, and I think we're still seeing how far the courts are willing to go on that. You know, to pick up on Chip's point, I think hope springs eternal, but time will tell whether or not that will make meaningful contributions to correctional law.
I agree. I think Kate's analysis is absolutely correct, and you have to argue it, and it is an improvement. Hopefully, it'll be a more significant improvement over time.
And just to go back to the reasonableness thing, just for participants, you know, pre-Kayla, of course, while in my view it was very clear on the law that you could review reasonableness of habeas corpus applications. What led to, one of the things that led to Kayla was that they were saying reasonableness is not a topic for review on habeas corpus applications. So you could determine whether or not there was procedural fairness or whether something was arbitrary, but you couldn't look at reasonableness at all. And of course, the court did with that what it is. But again, and I think Kate alluded to this, there is this fixation that the courts have with deference, and it continues to be a problem. And Justice LaBelle said that we don't want to micromanage the prisons. And that seems to be a huge fixation by the courts. They don't want to engage in that micromanagement, but sometimes it's necessary to step in when they do. So the whole reasonableness thing is something that is going to continue to, let's say, dog us as it goes forward. Okay, one final question we have here is that, are there any 2020 cases which illuminates on the nature of the SIU regime and whether it actually has ameliorated or worsened prisoners' rights? I'd probably ask Chip to first deal with this. I can just say I don't think I know of any, but then I'm not the person to ask probably. And if there aren't any, maybe Chip, you could talk about what you see happening in the event that litigation occurs.
Well, the quick answer is I'm not aware of any cases. I can only add, I guess, repeat what I said earlier. There are some due process issues that I see arising, and I would urge every lawyer to be alert on a case-by-case basis to issues and address within the framework of the legislation and the charter, address issues as they arise.
Any other comments? Okay, well, there's still an opportunity for any more questions if anybody wants one. We've got a few more minutes.
There was another question about the use of the correctional investigator, and I typed an answer to it and then I see it disappeared. So
yes,
basically Jay Chalk said, well, given our lack of success or frustrations with civil litigation, have we turned to the correctional investigator or ombudsperson, and can't they help us, and so on and so forth. And I typed back, and I could read it to you if you want, but in 1977, during the Steinhauser hostage-taking trial, we called Inger Hansen, the first correctional investigator, to the stand on behalf of the prisoners. And she confirmed that in her very first report, she essentially condemned what was going on. She said she had no expertise as a psychiatrist or a psychologist, but she described her observations, and this is in 77, we're talking about 75 to 77, her own observations of what she saw was happening to the various prisoners. And so it was a result of her first report that we had the Van Tour Commission, which is, I think, the first one that criticizes solitary. So we've had umpteen different reports over the years and excellent reports from our current correctional investigator and earlier correctional investigators about the situation. And so those remedies too don't appear to be effective in order to try and solve this problem.
Actually, if I can ask John, since we've got a couple of minutes on that, because you mentioned the first correctional investigator, and I think 75 is what you said. What do you know about what led to the establishment of that office in the first place?
I don't know the exact details, but I think my recollection was again, it was all about trying to provide peaceful remedies because of what was going on. I mean, this was a period where we had riots reasonably regularly, and hostage takings. I mean, no lawyers were going into the prisons. People were not, attempting to ensure that the rule of law applied in prison. It was a completely arbitrary situation. If you read, McCann, and read some of the evidence in McCann in terms of what was going on at the BC Pen back in those days, it's unbelievable. Well, no, it isn't unbelievable to us who have seen these things going on, but to most people, they would shake their heads. And again, it's because we're dealing with people at the bottom rung of the ladder and so on. And so I say, I wonder if there's a way that we can show how they are damaging themselves while they do this to other people. But again, frustration, but the nature of the beast, I'm afraid, creates these problems.
Well, great big thank you to all of the panelists. A thank you to Adelina Iftene as well for organizing this, as well as to Murray Follis for also his work in organizing what I hope has been a very illuminating panel for all participants. I see another question has come up. or maybe it hasn't. Oh, somebody has just said that Bromby 2020 BCSC 1119 was an HC decision dealing with SIUs. The analysis was fairly limited to the individual prisoner, though, not commenting much on the overall regime. Well, thank you, whoever you are, for sharing that with us. That's very helpful. I also wish to remind everybody that a recording is being made of what of the panel today, and will be able to be accessed at a later time. Thank you once again, everybody, for your attendance, and I hope it's been very helpful and illuminating for you. Thank you.